Okay, hello, and welcome everyone to the fourth and last installment of the Law Reviews Symposium, Safeguarding Tomorrow. The students from the Law Review, including Lyndall and Charlotte and Isabella, have done an amazing job and have worked really hard to bring us some exceptional panelists today, who I'll be introducing in just a moment. I'll be moderating the discussion today, which I hope will be a lively one. And for those of you who don't know me, I'm Margaret Olnick. I've been teaching here at Vermont Law and Graduate School since 2018. Some of you may not know that family law is one of the most dynamic areas of the law. It changes really more frequently than any other type of law. And it's interesting because many of our students come here for our top-rated environmental law program. And yet, despite their strong interest and unwavering support of the environmental movement, sometimes they realize once they're here that family law is their jam. It's certainly an area of practice where we need good, competent, and ethical lawyers who are interested in helping people and trying to better the lives of their clients, whether they are the parents or the children themselves. So it's why I'm so excited that the Law Review has decided to make children's rights and children's issues the focus of their symposium this year. So far in the symposium, we've explored the impact of recent Supreme Court decisions on ICWA, the Indian Child Welfare Act, and its long-term implications for Native American children, the legal and ethical frameworks addressing AI-generated child abuse material in the United States, and the rights and well-being of LGBTQ youth. So, how many of you have attended one of the prior panels? A bunch of you. Great. So today we're going to wrap up with labor law. We will be discussing child labor laws and protections, or the lack thereof, for working youth involved in social media. And we're going to be doing that today with an audience who grew up with the full impact of social media and probably have a lot of personal experience with this topic. Our audience here may have extensive digital footprints of their own that they had no say in creating. On this note, I invite you to think about how you feel about the way your parents may have shared your life online and while you were growing up. And I'm wondering how that impacted how you think about privacy today. We're going to reserve some time at the end of the panel, starting at about 1:45, for you to ask your own questions of the panelists. So I'd like to introduce those panelists now who are online. Professor Leah Plunkett was the founding staff attorney for the Youth Law Project at New Hampshire Legal Assistance. She's now a Harvard Law School lecturer and a faculty associate with the Berkman Klein Center for Internet and Society, also at Harvard. She's the author of Sharenthood and a frequent commentator on digital law issues facing youth and families in media outlets around the world. Welcome, Professor Plunkett. Professor Stacy Steinberg is the director of the University of Florida Levin College of Law's Center on Children and Families, that's in Gainesville, where she narrowly survived the storm last night, and we weren't sure if she was going to be showing up today until just a little bit ago. So we're happy that she has arrived. She is the author of a book called Growing Up Shared, which she has also shared with various media outlets. She's a master legal skills professor and supervising attorney for the Gator Team Child Juvenile Law Clinic. Welcome, Professor Steinberg. We also have Professor Naomi Kahn, who is a professor and legal scholar at the University of Virginia School of Law. She specializes in family law, trust and estates, feminist jurisprudence, reproductive justice, and aging in the law. She also directs the Family Law Center at UVA. Professor Kahn has co-written casebooks in family law and trust and estates and has many published articles. Her work has also been featured in prominent media outlets, and she's a frequent contributor to the Forbes Leadership Channel on gender equity. Her most recent book is called Fair Shake. It's about women and the fight for a just economy. She may not be aware, however, that about a year ago or so, we started using her family law textbook in my family law class. So welcome, Professor Khan. Finally, we have Senator David Kaler, who hails to us from South Dakota originally. Prior to his becoming a lawmaker, he was a staunch advocate for migrant farm workers, a community organizer, and a program manager for Peoria Friendship House. Senator Kaler has been on various boards and commissions involving labor management, relations, and healthcare. He was elected to the Illinois State Senate in 2006. He became the Majority Caucus Whip in 2018 and the Assistant Majority Leader in 2019. Senator Kaler recently sponsored a bill, Senate Bill 1782, which became law in Illinois, and it ensures that minors under age 16 who are featured in vlogs will be compensated for their labor. Welcome, Senator. Thanks for being with us. And did I get that right, that you're from South Dakota originally?
Originally, yes.
Okay. And so now, before we get to our panelists, and as a way of introducing the topic today, we'll hear from our own Gabby Miller. Gabby, in addition to being a proud cat owner, is a third-year law student, a student aide at the South Royalton Legal Clinic, a member of the Vermont Law Review, and is well known for her kindness and supportive nature. Her recent note is titled, "Beyond the Yellow Brick Road, the Burgeoning Issue of Child Exploitation in Modern Media," and it tackles these issues, critical issues of child exploitation. So Gabby's presentation will be followed by remarks from each of the panelists, and then we'll have a few facilitated questions, and then we'll have questions from the audience. So please welcome Gabby for our first presentation.
Hi, everyone. Before I start, I just want to thank Lyndall and Charlotte for their hard work in making the symposium happen. They did an amazing job. I also want to thank Bella for all her support, but I especially want to thank Lyndall for inviting me to speak today. It really is an honor. I just want to give everyone a quick content warning that I will be discussing instances of child abuse, so just be aware of that. So to give you a quick introduction, from the early days of cinema, the issue of child exploitation has pervaded the entertainment industry. The passing of the Coogan Law targets children in entertainment with a focus on rectifying problems specifically within the film and entertainment industry. As a result, child performers on social media remain largely unprotected. Children that are featured on their parents' social media accounts do not fall under the protection of the Coogan Law, and child entertainers in general are not protected by the Fair Labor Standards Act. Unless new laws are implemented to combat these issues, children will remain vulnerable to exploitation. So some examples of exploitation from old Hollywood. First is Judy Garland. Her story actually inspired my interest in this topic. And if you know anything about MGM's 1939 film, The Wizard of Oz, it was kind of a mess behind the scenes. But aside from that, Garland's mother would drug her with stimulants so she could stay awake for 72-hour shoots, and would then force feed her sleeping pills so she could, just to knock her out when she wasn't required on set. At 16, Garland was groped and harassed repeatedly by Louis B. Mayer, the co-founder of Metro-Goldwyn-Mayer Studios. Next is Brooke Shields. Her mother hired a photographer to take nude photos of her for Playboy when she was only 10 years old, and at 11, she portrayed a child prostitute in the 1978 film Pretty Baby, during which time her mother was also her manager. And at that time, Shields also understood that her career provided the family's sole income. Finally, Shirley Temple was fondled by grown men in multiple of her films, and she depicted a prostitute in the movie War Babies when she was only 3. When she was 12, movie producer Arthur Freed exposed himself to her, and in 1945, she discovered that most of her childhood earnings had been frittered away by her parents and relatives. So these examples establish a pattern of parents stealing the money their famous children earn and disregarding their children's well-being for the sake of fame and fortune. So one law that does target child labor is the Fair Labor Standards Act, the FLSA, which child entertainers are exempt from these restrictions, and these restrictions cover the amount of hours they can work and what type of work children can perform. So this means that state laws control the regulation of their work within the entertainment industry. So these laws have major discrepancies from state to state. For example, California has extensive requirements as compared to Georgia, which only requires the issuance of a special permit and written consent from the Commissioner of Labor. Children are generally not allowed to do work that puts them at risk of injury or work that interferes with their education, but these provisions do not apply to children employed in theatrical or movie productions. So while child movie stars do have some legal protections based on state-specific laws, children who perform on social media do not have any protections because they are not considered employees. So the Coogan Law is a California law specifically targeting child performers. One of the first child movie stars was Jackie Coogan, and he achieved stardom when he performed the lead role in Charlie Chaplin's movie The Kid. When Coogan turned 21 and went to claim his fortune, he discovered that his parents had spent all of it, and after suing his parents, he only was able to recover $126,000 of the $4 million he had earned. So this situation provided the basis for California's Coogan Law, which ensured that a child performer's contract must set aside a portion of their earnings in a trust, which the child could claim when they reached the age of majority. This still did not prevent child exploitation completely. Some of you might recognize Home Alone star Macaulay Culkin. His parents took 15% of his earnings in a situation where Culkin was already the family's sole source of income. The Coogan Law has since been reformed to target these issues and now requires that 15% specifically of a minor performer's contracted earnings be set aside in a trust. So social media is a fairly new phenomenon, and as such, child entertainers on various social media platforms, also known as child influencers, are not afforded many protections. Currently, the Coogan Law does not apply to them. For minors, the law requires parental consent for the collection, use, or disclosure of personal information, but this doesn't provide any protections when the parents themselves are spreading their children's information for monetary gain. So parents are beginning to exploit their children on social media the same way young stars in old Hollywood were exploited. Legal recourse in these situations is more complicated because social media allows parents to be guardians, managers, and producers all in one. So one example, I don't know if any of you have heard of Ruby Frank, who ran the 8 Passengers YouTube channel, which featured the daily lives of her and her 6 children. Frank openly abused her children, reportedly taking away their bedroom privileges and often withholding food as a punishment, and all of this was filmed for the entertainment of her millions of followers. And she was arrested after her 12-year-old son escaped their home in a state of malnourishment and suffering from physical wounds. And then another example is Mika and James Stouffer, who ran a YouTube channel dedicated to creating family-oriented content. They adopted a child from China specifically to gain more views. Documenting this adoption process did bring them hundreds of thousands of views and followers. But when the behavioral issues of their new child became too much, they ultimately returned him and gave him to another family. So these young social media performers fall into a gray area where their work does meet the definition of work because they are generating income, but it's not considered as legitimate as child performers on film and television. Now, one of the most egregious issues that child entertainers face is being sexualized. Some parents will sell exclusive VIP photos of their children or create Amazon wish lists where fans can buy gifts for their children. While this is not technically illegal behavior, parents who engage in this behavior are often sexualizing their children. One example is 4-year-old Ren Eleanor, whose mother would post videos of her on TikTok. Viewers expressed concern about possible sexual exploitation of Eleanor due to the questionable content, fans that were suspected pedophiles, and inappropriate searches for concerning videos featuring the 4-year-old, with search terms like Renan's scandalous outfits being prevalent. So the U.S. Does not have laws in place that sufficiently protect child influencers. Similar to the arrival of film, the advent of social media brings novel issues to the legal field. And children whose careers are completely controlled by their parents have no limits on how many hours they must work, and there are not any specifications on how much of their earnings should actually be allocated to them. It is not clear whether children performing for their parents' social media accounts is officially considered child labor. While these children are certainly working, it is difficult to regulate that work because it is within the family and parents generally have a right to raise children the way that they want to. Supporting this sentiment is the Supreme Case Meyer v. Nebraska, which held that individuals have a right to establish a home and bring up children according to the dictates of their own conscience. On the other hand, however, Prince v. Massachusetts stated that states do have the power to regulate the family in certain instances, especially when it comes to child labor as it pertains to child welfare. A prevalent problem that child influencers face is that they often work excessive hours at the behest of their parents. However, in its definition of oppressive labor, the FLSA explicitly excludes parents. This means that when parents inflict these oppressive labor conditions upon their own children, the law does not recognize it as illegal. So an associated issue here is intellectual property. So according to the Copyright Act, copyright protection applies to original authorship. Since many child influencers are too young to make their own social media accounts or are forced to perform for their parents' accounts, they do not own the content that they participate in, their parents do. Even if child influencers cannot fully own the work they help create, being recognized as the creator's employees would mandate financial compensation for their work. So international and state laws are beginning to address all of these issues. The French legislature is contemplating a new bill that would allow courts to prohibit parents from posting their children online altogether. And French law also requires YouTube channels featuring children under 16 to obtain official authorization from an administrative authority. Thailand specifically prohibits adoptive parents from posting their adopted child's photos or information online before the adoption is finalized. This is especially important because there was one couple, the Philippines, who specifically cited this law as the reason they did not go through with the adoption of a child from Thailand. Their issues with the social media restriction implied that the main reason motivating this adoption was the fact that they would be able to generate income from the adoption process. And India has proposed a rather strict law that would completely limit social media usage for people under the age of 21. And then in the United States, a recent Illinois law protects online child performers. So this law is based on the Coogan Act and mandates that child influencers are entitled to a percentage of their earnings from content that they participate in creating. So the U.S. should create a new federal law that specifically targets protection for child influencers, because this realm is subject to equal opportunities for exploitation as the movie industry. Federal law is important because it would provide standardized protections in every state. So some suggestions include allowing children of a certain age to request that content featuring their image be taken down, targeting the issues of sacrifice of privacy, excessive hours, and lack of fair compensation that child influencers face, and they should be given the same protections as children working within the realm of traditional media. So why is this such an issue? Parents can damage their children's mental health by oversharing their lives on social media. Children's work goes uncompensated, and children lack control over their own image, and once their pictures and videos are on the internet, there is no way to erase them. So one example comes from Kami Barrett, who grew up with her mom constantly sharing personal information about her on the internet. She experienced many negative effects from this type of oversharing, and after suffering stalking and bullying due to her online presence, Barrett eventually dropped out of high school. She is now extremely private and does not have a relationship with her mom. So, in conclusion, child exploitation has lasting effects that could be rectified by the implementation of new legislature. Thank you.
Thank you, Gabby. So now we have our four panelists, and I thought, my understanding is they each have some prepared remarks each. So why don't we start with Professor Plunkett? Would you like to address us? Thank you and welcome.
Thank you so much. It's a pleasure to virtually visit my friendly neighbor to the north. I live in Concord, New Hampshire, and I was about to say Zooming, but Teamsing in from there today, and hope that you are all enjoying the kind of beautiful foliage and weather that we are down here in the Granite State. So by way of a bit further introduction and a few thoughts, and then very excited to hear from my distinguished co-panelists. I started my career in law post-clerkship as a legal aid lawyer. As was mentioned, I was the founding staff attorney of the Youth Law Project. This was at New Hampshire Legal Assistance. I know that we have some folks who have interned there or done externships, which is wonderful. And this was back in 2007. And I did that for a couple of years before becoming a consumer rights lawyer. Then I became a legal academic and started really focusing a lot of my work on this intersection of youth law and internet law. And when I started that focus, I definitely got a few questions along the lines of, what does being a juvenile justice lawyer and being a consumer rights lawyer have to do with internet law? And my response then, this is back in about 2011 when I left practice and became an academic. My response then, which is still my response now, but I think now a few more people kind of resonate with it, that I would say that in so many ways, the history of internet legislation and regulation is really a history of legislation and regulation around youth, families, schools, and homes. But to focus in now on how I came to this topic of child influencer labor law, I came to it by way of the book I wrote on parenting, and with thanks to Professor Steinberg, whose law review article was foundational in my work, and on her law review article called Parenting, and her fabulous scholarship continues to be. So I wrote this book about how parents, teachers, aunts, uncles, coaches, and other trusted adults really lacked any meaningful regulation about what they could say about kids online. More regulation in the space of schools or other professional caregivers and teachers, but really when it comes to parents and in-home caregivers, almost no regulation. And in this book, I had one chapter on a topic that I called commercial parenting. How many of you have ever heard that term? Okay, we got a couple. Wonderful. Well, usually it's no one, as the term, child or family influencer or vlogger tends to be more common. But I was coming to this topic from, hey, at what point do we go from mom, dad, or other parent just likes to take pictures and put them online, take videos, put them online, share private content in a whole bunch of ways that don't involve social media? And when is it a business? And I argued then, and still would, that when you get into the realm of mom, dad, or other parent receiving or hoping to receive some form of financial compensation, it is a family business, meeting and entertainment business, and that at this point in the US, we really are the headquarters. And sometimes the headquarters can be around individual kitchen tables, quite literally as well as metaphorically, but we're the headquarters of a global, by many estimates, multi-billion-dollar a year, virtually unregulated entertainment industry that turns on child labor, and that it is hugely problematic to have any industry, but especially, and thank you so much for that fabulous presentation that focuses us on this history, but especially problematic to have an entertainment industry that focuses on unregulated child labor, given the repeated difficulties and tragedies and crimes in some instances we have seen from Hollywood, Broadway, and other brick and mortar stages. I had the pleasure recently of going out to LA, that other coast, and joining some folks at Hulu for the premiere of a new documentary called Child Star. And in Child Star, I briefly appear as a legal expert, which is fun, but really it is worth watching, not for me, because you basically are hearing what I'm saying now, but for two reasons. One is co-director Demi Lovato does a wonderful job really bringing intimate stories from her own life and the lives of some of her fellow, what I might call 20th century focused sort of celebrity paths or early 21st to life. They're adults now and they can share as they want. And also Child Star does extraordinary work chronicling the activism of Chris McCarthy, whom I know you've worked with, Senator. Chris is a phenomenal activist from the University of Washington, who has been one of the leading voices, along with a wonderful young person from the senator's home state, Shreya, in terms of doing activism and coalition building around reforming child labor laws at the state level, and perhaps someday at the federal level, to get ethical, practical protections in place for child influencers, aka commercially sharented kids, vloggers, and so on. I won't say too much more about that because I'm sure the senator has much more detail to give. One thing I will add before I turn this over is to say that I have been, over the last half a year to 3/4 of a year, serving in a new and really, really exciting role. Thank you, Professor Khan, and you and Professor Steinberg and the senator and also the senator's staff have been part of this effort too. The Uniform Law Commission, which serves among many functions to provide uniform or model acts for states to consider adopting, convened a study committee early this calendar year on the definition and protection of a child's interest in the child's name, image, likeness, or other intellectual property. I have the privilege and the pleasure of serving as the reporter for that study committee. So I am working alongside a committee chair and co-chair who are two commissioners. They are part of the Uniform Law Commission. They're terrific. They're representing Missouri and Nebraska. And under their guidance, we are looking, along with other commissioners and other wonderful subject matter experts and stakeholders like my fellow panelists, at should we recommend to the Uniform Law Commission that they convene a drafting committee to consider actually writing a model or uniform state law, building on the tremendous work that's been done in Illinois, which has the only law currently in effect. Also, laws have been passed in Minnesota and California. Demi Lovato actually joined Governor Newsom for the signing of the California one shortly after the premiere of Child Star on Hulu. So always helps to use entertainment to get reform around entertainment. And roughly 20% of other states over the past several years have considered or moved to committee or otherwise been engaged actively with some type of child digital entertainer, which is the terminology our committee has been using a bit, just to reserve judgment on the on the exact language, whether there should be a model or a uniform act that states could choose to adopt or to adapt and then adopt. That's not to say that federal legislation wouldn't be or couldn't be extraordinarily important, but just to elevate that there is another path for getting to some degree of uniformity in this important area. I will stop, but just say I misspoke earlier, so sorry, my notes just reminded me. Our committee co-chair is actually from Kansas. I misspoke. So with that, I'd love to hear what my fellow panelists have to say and excited for this discussion.
Wonderful, thank you. How about we hear from Professor Steinberg next?
Hi, everybody. Thank you so much for having me here. And it's great to hear the remarks of Professor Plunkett and from Gabby. Thank you. I'd start by saying that my work in this area found its genesis in self-reflection. I'm a mom to 3, I'm a photographer, I'm a former child abuse prosecutor, and now I am a professor. And what I've seen over the past decade or so is that sharenting, or the practice of parents sharing online about their kids, has really become mainstream in American society. And while most forms of sharenting might be considered benign or perhaps even helpful for families, there's something beyond sharenting that takes place when parents financially or otherwise benefit by oversharing personal information about their children online. And this exploitative form of sharing is currently classified in the same bucket of other less controversial forms of sharenting. And what I'm arguing in my next article in my work right now is that we need to create a separate bucket to hold this more exploitative form of sharenting. And in my new work, I call the contents of this bucket beyond sharenting. This new bucket of beyond sharenting calls for regulation. And while I agree 100% that labor laws must be one part of this new legal scheme, I argue that it alone is insufficient to meet the growing needs of children who are being exploited by their parents online. What I hope to offer in this work is a child welfare-based scheme that protects children online, that's overseen by state child welfare agencies and dependency courts. And that's where most of my time is spent now when I'm not teaching, is advocating for children as attorney ad litem in dependency court. In the 1800s, spanking a child lightly and beating a child all fell within the same bucket of parental rights. But now 2 buckets exist. Parents can use corporal punishment to the extent that's permitted by law, the first bucket, but if they go further than legally permissible, they have jumped into the second bucket, in which lies the realm of child abuse. Parents can currently share online about their children with unfettered discretion, just like parents used to be able to discipline their children with corporal punishment any way that they saw fit. Much like child abuse now falls outside the bucket of acceptable parental discipline, oversharing about children publicly and for profit could potentially fall outside the bucket of reasonable sharenting if it is harmful to the child. And when parents go beyond sharenting, parents have engaged in a course of conduct that calls for state intervention to protect the children. My work argues for this new model of children's online privacy protection that models the evolution of child abuse laws in our country. I argue that the United States must separate reasonable parental sharenting from online abuse and exploitation, and that our child welfare system must evolve to be designed to address online abuse perpetrated by parents. Utilizing the doctrine of parents patriae, the model could recognize that there are limits to parental autonomy, not just in our brick and mortar world, but in our online world as well. And since this would be a new realm of state intervention, it has to include a public health campaign that educates parents of the differences between reasonable sharenting and online child abuse and exploitation. Alongside that, though, it has to include regulations that allow the state to regulate parents who, despite the public health efforts, continue to exploit or otherwise harm their kids online. A case that is often cited as creating the first child abuse laws in this country, Mary Ellen Wilson, tells of a young girl who was physically abused. While her injuries and the neglect Mary Ellen suffered was gruesome, concerned citizens were hard-pressed to find legal ways to help protect this child. A lawyer, at that time the president of the New York Society for the Prevention of Cruelty to Animals, was able to successfully argue for her protection, citing animal welfare laws. Child protection laws grew from that point forward. Some people would likely suggest that sharenting is a realm of family life where the state just shouldn't enter. But there are many realms of family life that the state has refused to enter in the past and now thankfully wades into thoroughly. Like sharenting, parental discipline was once part of that realm, and it was only after the case of Mary Ellen Wilson did the state recognize that at times children needed protection from their caregivers who abused their privilege. I want to conclude by highlighting that any attempt to limit parental rights to share on social media must be done with the strictest of scrutiny, as parents' rights to determine how to raise their children is a fundamental right. I also would add that parents generally do not wish to harm their children. In my work as an attorney in the dependency system, I found that parents abuse or neglect their children, not always because they're intentionally malicious. Many do so because they do not have the resources that they need to make better parenting decisions, or they are unaware of how they can better meet their own needs and the needs of their children simultaneously. Similarly, parents rarely exploit their children online because they are being intentionally malicious. Many do so because they are unaware of the risks that oversharing presents, or they need the financial assistance that such oversharing provides. A key principle in child welfare policy is the role of the state to strengthen parents. Of course, states need better research to understand the risks that can come, like from Gabby Miller's examples with Judy Garland, Brooke Shields, and Shirley Temple. They need this additional research to create better best practices for parents who choose to share about their families on social media. Some will likely do so with good intentions, like those who try to raise awareness of medical conditions to sway public policy in matters that are important to their families, or perhaps even to raise money. I personally used to take pictures of children with chronic medical illnesses and help those families share those pictures to raise money for the family and to raise awareness of the medical conditions that the children suffered. We place so much effort on giving parents tools to help their kids share smarter on social media, but we put so little attention on our own behaviors as adults. Hopefully the law can step in more than just the labor law area, but can find broad solutions to help protect children from parents who engage in harmful sharing practices. I think this is an area that's really ripe for future interdisciplinary research, and that begins with conferences such as the one we're doing today. Thank you.
Thank you so much. Great. And Senator Kaler, how about we hear from you next?
Let's unmute first. Thank you. It's a pleasure to be here. I feel a little bit inadequate with all the expertise that is here, but let me tell you the story about Illinois. So I had a young woman in my district in the Bloomington Normal area, which is central Illinois. And she wrote a letter talking about just some of her concerns. It was actually part of a project that she was working on for class. And so she outlined a lot of the things that you described and said, we really need to have some legislation that protects children in this regard. So we put together, we got our legal staff involved in this. We got in touch with Chris McCarty from Washington, and she's a real resource. She's a superstar in this area. And so the young one from my district, Sharia Nalamathu, you mentioned Sharia before. We had our legal staff put together the law. At first, what we were presented with was not only to help figure out a compensation system, but to then also a system whereby if a child, once they turned to majority, could look back and remove content. That turned out to be a much difficult task because, first of all, it butts up against First Amendment rights, and secondly, how do you do that technologically? How do you remove something that's already been out there? So what we decided to do was really to try to just involve ourselves with the compensation aspect. How do we protect, a child who is used to generate lots of money for the family? How do you make sure that when they turn 18 that they have something to show for that? And we looked at the Jackie Coogan situation. I didn't know, I'll never look at Wizard of Oz again the same after hearing about Judy Garland, but these are true stories out there. We went through a couple of variations on this. We initially had the Department of Labor kind of tasked with being able to track some of these things, that if child stars are being used to generate income, families would have to report this. It got too complicated. We finally just said, this isn't going to happen. We're talking about something that may be years from now. So let's make this easy. What we did, we set it up for a right of legal action for a child once they turned 18 to look back and to see if their parents didn't keep records and didn't adequately compensate them. The way the law is written, I'll just read this to you. So at least 30% compensated content within a 30-day period that involves the minor, that the number of views per content reached on the online platform's threshold of compensation received actually where you generate it from, say, Instagram or whatever, or if it relates to 10 cents per view. So that's kind of the baseline. And what we said is that if a child is in, say, 50% of a family's video that's online and they are receiving compensation for that, well, then let's take and set aside 50% of that compensation for the child and put it in a trust fund. So in other words, if a child is in 100% of the video, then 50%, whatever the compensation would be set aside. Now, I think California has a little bit different approach in that, but we just had to start someplace. We recognize that a family does use this as an enterprise. And so there's, a legitimate need for the family to be compensated for that. But we want to protect that child. And if there's 2 children that are involved in that, well, then they split that amount between the 2 children. I think it worked out fairly simple. Again, this went into effect this past summer. Amazingly enough, we had both Chris McCarty on video and Sharia there in person at the hearing, and they blew everybody away. I mean, they knew so much about this. They were so impassioned about it. This wasn't based on my knowledge of what's going on here. This is based on Sharia's knowledge and Chris's knowledge. And it passed out of committee unanimously. It passed out of the Senate unanimously. I went to the House. They put on a couple of amendments. It didn't pass unanimously there because we have some folks that don't agree with much of anything. But it came back and we confirmed it in the Senate. And all of a sudden it took off. We were getting calls from CBS and from Wall Street Journal and the Washington Post, and Sharia really became a star in this. She has been all over the country testifying on this, and very, very bright young woman with quite a future ahead of her. I don't know whether she's going to go into law or whatever, but I think she's going to go into this area. So that's kind of the Illinois story. I'm glad that we were able to be the first, because I assumed, and I think will happen, that other states will follow. I like, Professor Plunket, what you were saying about trying to create a model. If we had something like that, it would have made our job much easier, because we had to kind of pick and choose what California was doing and Washington was doing, and kind of what our own practical experience said that would work. But it would certainly be nice to have kind of a prototype out there that we could just say, yeah, let's take a look at this. So that's the Illinois story.
Terrific. Thanks so much. And Professor Khan.
Thank you so much. I'm delighted and honored to be here, and I appreciate that I get to go last, and because I've appreciated what everybody else said. You've all been amazing and critically important to framing this topic, both in your past work and then also on this panel. And I had a PowerPoint, but there's no need to show it because you all have already covered much of what I would have already covered. I'd like to note, in response to where everybody is from, I grew up in St. Louis, Missouri, so not quite Illinois, and very different culture in Missouri these days than in Illinois. Yes, good luck trying to get this enacted in Missouri. So I'd like to start by noting that this brings to me this topic, how I approach this topic, and it brings together 2 different sets of issues for me. Obviously it's child influencing, but also I teach trusts and estates as well as family law. Thank you so much, Margaret. It's great to hear that you like the casebook. And I write about children's rights, family law, and trusts. Like Leah, I have worked at legal services, but I represented parents accused of abuse and neglect. So I kind of start with parents' rights in mind, but I've come around to think very much about children in this context. So I approach this because of the potential remedies that are involved in figuring out what to do about child influencing
as well as, of course, about acting. And I've talked about how we seem to rely so much on parents' rights. I've got an article with Mary Ziegler and Maxine Eichner talking about how parents' rights are so often used as a way of slipping in different political agendas. Here, parents' rights are being used as a way of making a lot of money and profiting from their children. So in terms of approaching this, I'm going to just talk a little bit about the remedy of trusts. Other remedies, of course, would be to expand labor law, expand the FLSA or state labor laws to cover this issue. And I appreciate that, as Senator Kaler said, this is a very long-term solution. It is not happening tomorrow, quite obviously, particularly given how long the child actor exclusion has been in existence, and they've been around a whole lot longer. I appreciate and I agree. I so hope that the study committee moves towards a drafting committee with the ULC. We do need a model act, and I appreciate Stacy's recommendations concerning expansion of the child abuse and neglect system. So I'm now going to very briefly use the lens of a T&E scholar looking to this corner of privacy and entertainment law, because it raises so many of the issues that we explore in trusts and estates of vulnerability, fiduciary responsibilities, and money. And I was at a T&E conference almost exactly 2 weeks ago talking about this issue. And there were about 100 people there, including attorneys in practice, other academics, and of course students. And I asked how many of them had ever heard of Coogan trusts. 2 people raised their hand out of about 100. So, which goes to show that Coogan trusts, now I should say it was not in California. I think had I been in California, there might have been more people who knew, but Coogan trusts obviously are not universally known, certainly within academia, and certainly not with respect to states. And so I think that shows. I also did a search in the trusts and estates literature about blocked trusts. Blocked trusts are the remedies that are so often used in Coogan laws, and it's a kind of trust that is used in the burgeoning efforts to regulate kidfluencing / excessive sharenting. And there's almost nothing written in the trust and estates literature about this. I find that shocking, actually. Coogan trusts have been around, well, not quite 100, about 90, a little bit, maybe 80 to 90 years. And one would think that there would have been some attention to that issue. So that's where that's what's caused me to look at these Coogan trusts. That's what's caused me to look at all of these trusts more, the remedy of trusts more generally in this context. We've talked about, and had you I shown the PowerPoint, you would have seen me talking about Lil Sandwich, Carolyn Easom, who is a wonderful viral, I'm not allowed to use TikTok on UVA resources, but apparently does a lot on TikTok, and who supported the Ohio Kidfluencer law, and who's done some great work on showing the abuses of childfluencing. I would have shown you Quit Clicking Kids, and I would have shown you some examples of seemingly benign uses of this over-sharenting, which turn out to be, when you look at these little cute babies selling products in their parents' blogs, and you kind of wonder, just what are the parents actually thinking? I wonder how much Ryan Kaji, the 10-year-old behind Ryan's World YouTube channel, who brought in over $30 million in 1 year, I wonder just how much of that will actually be put aside for him. And there's also, of course, a great deal of research and testimony from children about what kidfluency actually does to the children. So, and we've heard about that obviously earlier on this panel. So the remedies, of course, get into issues involving the parent-child relationship, because so much of this involves parents using their children. Sometimes they're third parties, and California has now expanded Coogan laws to include these third party remedies, as well as, I think, copying Illinois perhaps has expanded or has created legislation just this past month, signed the legislation, I think. Leah, you mentioned it, yes, dealing with this issue. And so, I mean, as we think about intervening here in parents' business, in parents who get a free ride from the Fair Labor Standards Act more generally, I mean, the children in child fluencying are doubly not protected when it comes to their parents, as well as because actors and child fluencers are not covered by labor laws in their states. So in terms of trusts to the rescue, the question is just what we are asking trusts to do in this context. And so if you look, for example, at the California Coogan law, the trustee shall establish a trust account that shall be known as a Coogan trust account at a bank, savings and loan institution, credit union, brokerage firm, or company for any contract pursuant to which a minor is employed. This is in the child actor situation. Louisiana does something similar. It requires that a trust fund be created for the benefit of the minor. The other states, similarly, when it comes to Coogan laws, require the creation of these trust accounts. We've heard about abuses of Coogan trust accounts, and interestingly, and perhaps tragically, nobody keeps track of what goes into these Coogan trust accounts and how the money is actually used, how many of them are actually set up. And although the assumption is that the parents will be taking care of their children, and most parents, I mean, of course, many of us on this panel have already told you that we are parents. We, of course, only have our children's best interests at heart, but these laws are designed for the parents who don't have their children's best interests at heart. There's nobody to make sure, even if you set aside 15 or 30, or as the new California law does, almost 2/3 of the money, there's nobody checking on what happens to the other money that these children earn for their parents. And so if we think about what actually needs to happen with these trust accounts, although the trust accounts are supposed to only be available to the minors, and there are very few reported cases on Coogan accounts. One of the few says Coogan accounts can't even be used to pay for the fees that banks charge for these accounts, but there's very little else that tells us how these accounts are being used or misused. In California, there's this mandate of setting aside 65% of a child's earnings in these trust accounts. Parents can be excused from some of these requirements if court approval, but no one is monitoring these. The remedies for breach, for example, say things like, if a vlogger knowingly violates this part or should have known that they were in violation of this part, a minor may commence an action. Well, how is a child actually going to know to commence an action unless a child is actually getting reports on what's going on? And yes, a 12-year-old child getting reports on what's going on with a trust account set up in their name, right? Imagine many of us, even in this virtual room or in the actual room, the types of monitoring that are involved in that would need to be quite sophisticated. And so we need to think in setting up these trusts how we can structure them to really help the child. Also, a child can withdraw the full amount at the age of 18. Is that truly the appropriate age at which we want a child to be withdrawing this? To whom should these annual reports be sent? Do we want parents to be serving as trustees? How do we ensure that the money is actually going to these trusts? Do we want special record-keeping requirements? Do we want state or federal monitoring of this? How do we ensure that this money is actually protected for a child? Now, I'm just focusing on, in conclusion, I'm just focusing on one small part of this overall issue. You've heard a variety of other solutions, including, we could move to a complete ban on this practice. That would be very difficult to enforce. We've got the potential monitoring, FTC getting involved, regulating social media platforms is another possible solution. And at this point, trusts are doing a lot of the work that need to be spread beyond trusts. Thank you very much.
Thank you. So I'm wondering if you can explain, I know that we have this other vehicle, Uniform Transfers to Minor Act, where parents can set aside money for their children, and how that differs from a Coogan trust. Can you explain that?
I'm wondering if Leah wants to talk about that,
Yeah,
given your work on the ULC, because I assume it's something you're considering.
any of you to jump in as appropriate. So.
I am happy to defer, Professor Khan. I'm not a trust and estates expert. I'm very happy to talk about the ULC work, but on the level of detail that I think is in that question, I would defer to your expertise.
Let me say that from what I've seen, the goal in some of these statutes is to have the transfers into these trust accounts treated in the same way as these UTMA or UGMA accounts. But they are, I have been quite shocked. I've looked for research on what these block trusts actually mean. Although there's been lots more written on UGMA, Uniform Transfers to Minors Act, et cetera, there's been very little written about these block trusts. The laws do seem to treat them differently, but say they should be set up in accordance with the standards of UTMA, UGMA. Those laws, UTMA and UGMA, have already gone through the entire process that Leah Plunkett is currently starting with the Uniform Law Commission. They are in, one of my slides was going to show you, in fact, that they are in effect in all states. Again, relatively little monitoring. The child does get, and then there's actually currently a study committee of the ULC looking at whether UTMA itself, Uniform Transfers to Minors Act, needs to be reformed. I am hoping that one question would be what to do when the child turns the age of 21, as well as better monitoring. But at this point, they are two separate types of accounts, each set up at financial institutions, and often in the Coogan area, there is a reference to using UTMA, UGMA standards.
Right, and those with...
And by the way, that's a great question, and that's one of the reasons that I'm so fascinated by this, because so little has been written.
Right, yeah, so my understanding with UTMA accounts is that they belong to the child, but I think the child must request to have an accounting, otherwise there's no requirement to provide that. And those accounts are generally created by parents or grandparents who are setting aside money for their children. So I was curious about the idea of a block trust. That sounds like the parent cannot access it. And just to be clear, are you saying that the parents, even though it's a block trust, there's no monitoring, so a parent could withdraw funds from a block trust?
Well, there's, It is supposed to be blocked so that no one can withdraw funds. That's how the block trusts are defined in the laws that apply there. So theoretically, a parent is unable to withdraw the funds. On the other hand, the parent can get the funds before they're put into the blocked trust. The question of whether a parent can withdraw from these block trusts is, of course, going to depend on the financial institution. And then there's that question of just what kinds of reports are going to be available to whom.
Okay. As we look at the Fair Labor Standards Act, a couple of you mentioned, why can't that, can you just tell us generally about the Fair Labor Standards Act and why we can't just use that to update that law to address some of these issues? Why do you think a separate law is required?
I'm happy to speak to that. First, I think theoretically, if there were the appropriate will in our federal legislative branches, we could reform the Federal Fair Labor Standards Act to include all child entertainers, including child influencers. We could reform it to include child influencers and continue to leave the state schemes in place for brick and mortar child entertainers. I certainly think that there is tremendous value in having a federal law when you are dealing with an industry here, the child influencer industry, that may be kitchen table based, but not just national, but global, ultimately in its distribution. I would just be very surprised if there were federal will to do that. The federal legislature, both at the House and Senate level, seem pretty unable to come together on issues around minors, families, and online safety, despite tremendous bipartisan will. And there really does seem to be pretty tremendous bipartisan will. We saw some action this summer at the federal level with the passage of what is now being called COSPA. The alphabet soup of acronyms in this space never fails to make me smile, but in July, the Senate did pass a version of the long-awaited COSA, Kids Online Safety Act, and also COPPA, Children's Online Privacy Protection Act 2.0. They kind of merged them together to give us COSPA. I believe COSPA has been marked up in the House as of the fall, but the last time I looked, I hadn't seen any movement there. So in theory, yes, the Federal Fair Labor Standards Act could be modified and do a lot of this work. In practice, I don't see there being the will to do that. I'll also add that I actually see, even if there were the federal will to do these things, I am increasingly of the mind that preserving tremendous state flexibility is also very, very important here. That's not to say I would reject federal efforts. I would welcome them, but just to add that, our state lawmakers, as the senator's wonderful story, which, by the way, you were too modest to mention, Senator, was recently profiled in Rolling Stone, among many other media outlets. So Rolling Stone magazine has a great recent write-up, and many others have as well. But really illustrates the ways in which our state lawmakers can be so much more responsive to constituents. So minors, families, youth-serving professionals, and so on, than our federal lawmakers can be, and that states historically have had such an important role in terms of preserving child welfare. And Professor Steinberg can speak to that far better than I can, as can Professor Khan, and also drawing some of these tricky boundaries between child privacy, parent privacy, family privacy, as well as regulating family businesses. Again, you could reform the Federal Fair Labor Standards Act to try to regulate family businesses outside of child entertainers and child influencers. I personally think there's things about that would be beneficial, and a lot that would actually be ill-advised, because you would lose the ability of the families being regulated, both at the family entity level and the level of the individual child and family and parent or guardian, to actually be working under a state statutory scheme as interpreted by the courts and, of course, with state common law and the state constitution, to just be more responsive to the realities of that jurisdiction.
And I know, so you're
Oh, wait,
working-
can I just,
sorry.
I'm sorry,
Yes,
can I
please,
just
jump on it.
add to that and say, I totally agree with everything that was just said. And just to note that states are actually moving to try to, let's see, with respect to child labor protections, they're actually trying to undo them right now. So it's very much so that's a state by state thing. You can imagine which states are trying to undo protections for child labor. So there is something to be said for setting a federal minimum and then for having states move beyond that as appropriate, just so we at least have a baseline, because that's certainly what we've had in other fair labor contexts. But then, yes, let the laboratory of states do even better than what the federal government can do. But there is some, yes, the political will in Congress is quite difficult. And then there are the issues that Professor Plunkett ended with, parent-child privacy issues. We are dealing with parents and children, and there are certainly other issues currently pending before the Supreme Court, say with respect to gender-affirming care, that get into this very, very tricky issue of parents' rights and children's rights and privacy and decision-making.
Okay. And
There's also another part of this, that if I could just add to that, oftentimes what we see in doing state legislative work is that if we can get enough critical mass from other states, passing this, that it eventually will put that kind of a pressure on the federal government to do that. I agree with you. We ought to have state laws, but I'd also just like Congress to pass a budget. So we can wait for things, and they may never come. But so that's why I think states have had to move on some of these things.
Right. So, and it's your state, Senator Kaler, and did you say Minnesota? And is it just your state that has this new law? I thought there was a couple
Well,
of.
California just passed it.
California.
And I think that Washington has been working on it. I think Professor Plunkett, you mentioned that maybe Minnesota.
Minnesota has passed it, yes. So, Senator, you are the only state currently in effect. And in terms of the two states that have passed, we also have their Minnesota and most recently California. And also very happy to say, also on my list over the last several years of sort of taking it up in a serious way, Arizona, Georgia, Illinois, sorry, we said Illinois. So Arizona, Georgia, Maryland, Missouri, New Jersey, New York, Ohio, and Washington, in addition to the three that we just mentioned.
If we have some red states that do this, then I think it gives us the kind of momentum that can show that this is truly a bipartisan issue. So that's encouraging to hear.
Yeah. And it's encouraging to hear that the Uniform Law Commission is working on a uniform law. And I'm curious about how long it might take for that studied commission to come through. And for it to be, adopted by the Uniform Law Commission, and at that point, that's when it would become available to the states to then adopt or amend and adopt. So I'm just curious about the length of time we might expect. I know these things take time.
Sure. So I think the length of time we might expect would be that a formal recommendation would be made by the study committee within the next couple of months. And so if that recommendation is made to recommend a drafting committee, and a drafting committee gets convened, my understanding, this is my first go round with the ULC process, is that a drafting committee typically would be coming in at, 9 months to a year, maybe a little shorter, maybe a little bit longer in terms of doing its work. And this is an area where there are several issues that are very closely related to other either existing or potential ULC work. And thank you, Professor Khan, for your expertise. Literally my chart that I keep for my Uniform Law Commission work of the digital entertainer state statutes has written across the bottom of every page. This does not get into the details of Uniform Transfer to Minor Act. And so, because that is certainly something that would need to be taken up in drafting. So if assuming again that recommendation is made to go forward, recommendation is adopted, committee moves quickly, I would say that puts us at, that puts us at maybe next summer or fall, having something more fully before the full ULC at fastest. That is at fastest and not a promise. It is outside of my jurisdiction. But I think that there is a lot of awareness that with roughly 20% of states already moving and one new state law already in effect, that if the ULC wants to take this up in a way that can help lead, that sooner rather than later would be prudent. And Professor Steinberg, I think I saw your hand. I didn't mean to talk over you.
No, it's fine. One of the things that I was thinking about throughout this conversation and when I think about these issues is the word issue, and what is the issue that we're trying to address? Is it the profit or is it the harm that kid influencers that come from being a kid influencer? And I think that a lot of the solutions through labor law do address that profit issue, but it ignores the harm that's happening all along the process of this. When I think about the Fair Labor Standards Act, also, one of the things that I pull from when I teach child parent in the state is that many of our laws around labor, our labor laws, exclude parents. So for example, my child can work on my farm and I can pretty much designate how many hours they work and how dangerous the conditions are. But if they go work for my neighbor's farm, there's a lot more regulations. And so when we're talking about profit, our history has really suggested that we understand the role of kids in helping family businesses grow, in helping farms grow, and the internet is just kind of like the new family business and the new farm. What those situations recognize, though, is that somebody could call in and say that there's abuse taking place on the farm, there's abuse taking place in the business, and then there's a way to step in under a parent's patriae model. And so those are just some kind of pieces that I like to pull from with how the labor standards laws generally apply as far as protecting kids who work in family businesses. I also think it's helpful to think about rights. And when we teach child parent in the state, we often think about parents' rights, children's rights, state rights, and we kind of draw a triangle. And what I often talk about is that the idea of children's rights is something that is more of an idea than something that we necessarily see in our nation's history. Children have interests, and states are reluctant to intervene into the relationship between parents and their children unless there's first a showing of abuse or a showing of some sort of a harm. And so to me, it makes these issues that much more complex, but it still leaves the kids suffering from the harm as we kind of work through some of these financial pieces while the kids are still being exploited on the channels.
So do you think, given the ubiquity and the ease of use of social media, that we really are seeing a shift back to a labor force that includes children in large numbers?
Yeah, absolutely. And just like when that happened, it required a public health campaign to show the public why this is harmful. You can't get anywhere until you have public buy-in, and we don't have public buy-in yet. We still have a situation where even some of us on this panel and in this room probably get stuck, fall into the habit of watching some of these crazy videos where kids are being likely exploited because we don't really yet have a definition of this falling under exploitation. Just like before our child labor laws over 100 years ago, we didn't understand that sending kids into the coal mine was child exploitation and was harmful.
I should add that I'm not even sure we even see this as work. When you see that cute little baby in some of the vlogging videos, getting that to be seen as work, getting the child's image to somehow be protected really does require more of a public campaign so that we shift our images of what's actually going on in these videos. Going back to the earlier question, I do just want to say that with the ULC committee, anybody can sign up to follow it. I've been a reporter for 2 other committees, and we often have long, long lists of observers. So you just go to the ULC website, you ask to follow it. At some point, you will get access and be able to access the amazing materials that Professor Plunkett has already uploaded there. So for those of you interested in this and interested in the development, I would encourage you to go ahead and to do that.
And I might add, if I can, thank you, Professor Khan, a couple of very quick things. One is you had mentioned earlier Quit Clicking Kids, which I just wanted to take a moment to shout out as an extraordinary resource. That is a website maintained by Chris McCarty, whom the senator and I have spoken about. So Quit Clicking Kids does a wonderful job from that activist advocate perspective, tracking the current state of past and pending and prospective legislation. That's also a great resource. Next, I wanted to mention that I think that there may be, and I'd be curious to hear when we get into to Q&A, a bit of a generational difference or differences between seeing vloggers and influencers as doing work and not. I'm not saying you, Professor Khan, don't see them as doing work, but I think you are very accurately describing one of the limitations in existing law, that both the way it's written and honestly the way that a lot of us, again, not the panel, but just us being sort of our peers in the law, and whether it's on the bench or in the legislature or across sets of stakeholders, we literally just don't see that cute baby or that cute toddler or that cute 10-year-old as doing work. And my sense is that, and I'm happy to be corrected, I often am, that there may be sort of an ease that generations coming up now have in seeing that as work that we might not have. Third, I will confess that I am spending way too much time watching baby hippo videos on Instagram right now because I am obsessed with the baby hippos in Thailand. So if people want something to watch that is not human children, I highly recommend the baby hippos. My 13-year-old showed them to me. And last but very much not least, Professor Steinberg, I just wanted to say to your excellent groundbreaking work on beyond parenting in the child welfare space, Georgia has proposed, it was introduced, it has not gotten much traction, a law that would actually give minors involved in the child digital entertainer work, and I'm going to quote directly, a right to a work environment that is proper and not detrimental to the health of a minor, compliant with legislatively imposed scheduling restrictions, will not interfere with the minor's education, and that the minor will not be used for pornographic purposes. To date, Georgia is the one state I've seen that is trying to do a more welfare-based regulation, in addition to the approach that Illinois, Minnesota, California, Washington, and many states have taken, which is to try to really lift and shift the ethical, practical definitions and guardrails around Coogan laws and their close cousins in other states into the child digital entertainment space.
Awesome.
But we should recognize, and I appreciate your conversation on that and what Professor Steinberg talked about. Dealing with the labor piece or the compensation piece is probably the easiest part, because we can kind of define that. When you get into talking about what are the rights of parents and what is defined as abuse, then it gets real subjective and it really gets very polarized politically. So that's where, as states, we need more help in terms of creating the model. And I'm delighted to hear that a state like Georgia, which I do not consider as a progressive state, is talking about going into these things. That really helps us.
Yeah, thank you. I would think, just shifting to sort more parenting type issues, I would think that it would be difficult for a parent whose life is intertwined with their child's, even prior to their child's birth, to differentiate between their story and what is their child's story. So I'm just wondering if you have any suggestions on how we, maybe as lawyers or counselors or in our own lives, how do we navigate this topic with parents and especially those who insist that they have the right to share content about their children and they believe they know what's best?
I mean, I think that this has been kind of where my work has been for many years because I've spent so much time both in the courtroom for kids, but also taking pictures of very sick children in the hospital where the parent is trying to show what they've been going through and try to gather support for their child, but then recognizing as a children's rights person that that might have negative impacts on the child's right to privacy many years into the future. And where one of the things that I think needs to happen is that the idea of parenting, and I say it in the broad bucket, has to become a central part of child-rearing discourse. And just like we talk about how to feed our kids, how to help our kids fall asleep, whether to give our 5-year-olds YouTube, this needs to be part of that conversation that we're having at the dinner table and that we're having with peers, and frankly, that we're having with our pediatricians. I think one of the pieces that I wrote was with JAMA Pediatrics and with another pediatrician, and the idea that at Well Child Checks, when we talk about our children's use of social media, we need to also be focusing on our own. But then as lawyers and as policymakers, we can also pull from international views, which are very different than our own. A good example is my son was a gymnast for many years, and all the parents are taking videos of kids at gymnastics meets all the time, and they're sharing them on social media and tagging their own kids, but not blocking out the faces of others. When I shared that with my colleagues in Europe, they were shocked because it would be absolutely inappropriate for somebody to pull out their camera and start filming a group of children doing gymnastics or swimming. To them, that was not culturally acceptable. And so I think that we can learn from what our peers are doing in other countries, and we can also recognize that it's so normal in other countries to respect a child's privacy that they've adopted Comment 25, Children's Rights in the Digital Environment, recognizing part of the United Nations Convention on the Rights of the Child, that children have rights in the digital world. We haven't even adopted, we're the only United Nations member country to not have ratified the UNCRC, but they go just so much further than we do to pull up the idea that children are not just an extension of ourselves, but they are their own individuals.
Right.
One thing I often do in conversations with other parents, as well as sometimes with policymakers, folks from industry, my own students. I teach in the fall. I'm teaching right now at Harvard Law Youth Privacy and Digital Citizenship. I'll say, let's do a brick and mortar analogy. And I will say, how would you feel about that video of a child at gymnastics, to pick up on Professor Steinberg's example, being available for viewing on a billboard by the side of every highway everywhere in the world, now and forever, with no ability to know when new billboards are coming and no ability to have those billboards taken down? And of course, it's not a perfect analogy. You don't typically show videos on billboards, but it is a useful thought exercise to just take the thing that starts to feel so intuitive and easy when we're doing it this way and try to bring it into a reasonable brick and mortar analogy and just kind of see how that feels if you're a parent. And then if you're a policymaker, someone in industry, an attorney, start to then, in addition to maybe kind of doing that gut check feeling, start to play it out a little bit in a problem solving way. And you can start to see pretty quickly how all of these scenarios that, again, have become so second nature, whether we're doing them for profit or not, really start to feel a lot scarier, maybe even reckless and dangerous when you do a brick and mortar analogy.
I do want to give a shout out to the work of my colleague, Danielle Citron, who I know appeared earlier in this series, and a lot of her work on protecting privacy. And so the examples that Professor Plunkett was just talking about, that Professor Steinberg has mentioned as well, show the importance of protecting children's privacy. I do, on the other hand, want to note that I will say it was my 20-plus-year-old children who talked about how cute all of these videos were of vlogging parents showing their children and just how, well, I won't characterize their remarks any further, lest even though they're above the age of 18, they were the ones who first pointed out some of these. But there is also, I obviously firmly believe in the need to regulate. We also need to recognize that parents do find community in these groups as well. And so there's drawing these lines is difficult. And I suppose maybe one easy line is as soon as you start to make money off of it, we're concerned. That's one easy line. Before that, do we want to say parents should never include their children in any videos other than to, right? I mean, it's right that the lines are tricky here.
Yeah. Can you provide us with any guidelines parents should follow when sharing, if they decide to share their children's photos or personal identification online?
I mean, I think I'd be happy to. I think Professor Plunkett also has a number of them that she could share. Some of the key ones that I think of is never show your child in any state of undress. Consider how what you're sharing will impact your child, not just right now, but years into the future. Avoid sharing embarrassing stories. If you feel that you need to share vulnerable stories, consider using nicknames or not using the child's full name. I encourage parents to still give their children veto power over their online disclosures, and that might look different for a 3-year-old. You might say, can I share this with our friends and family versus with a 13-year-old? And then I think it's really important that parents recognize their role in role modeling. You know, our children are eventually going to be in charge of their own social media feeds. And if we expect them to respect the rights of their peers, not to have pictures shared of them when they're inappropriate or when they don't ask first, if we expect our kids not to share their own confidential information, like my own children may or may not have done at different times, we have to model that for them. We have to show them that our birth date with the full birth date is not something we put up for public consumption, that if we really want to share the fact that we got our driver's license, we need to make sure that we're covering personal information on there. And then just reminding them that, you know, we don't have kids go across the street before we first walk across holding their hand. We don't send them with a driver's license before we first give them a learner's permit, that we have a really important role to play in modeling social media safety. And I think that if we can put our minds in that place, that might be the best advice we can give parents.
Thank you, that's awesome. I'm wondering, seeing as we're at 10 to 2, if students have any individual questions of the panelists, and do we have a method to get them a microphone?
We do actually have a question.
Hello. How you doing, Senator Cater? This is General Parker.
Hey, General, how you doing?
I'm all right. How's Nora and the girls?
They're good. They're good.
Yeah, I had about a couple of quick questions, and you can answer whichever one you want. I was wondering, does this law cover other forms of exploitation other than just social media and vlogging? And I wanted to know, is there a certain demographic that's exploited more than others, whether it's sex, race, socioeconomic status, or whatever? And how do you plan to enforce or monitor it going forward? And what can we do here as students to help make this go nationwide?
I can answer part of that, but I'm going to defer to the other panelists on in terms of the exploitation. So, you know, what we dealt with, General, is just really the compensation part of it, and that's really kind of the easier part. One thing I wanted to mention was that you know, what we've given here is a right of legal action so that the minor can enforce the full trust provisions to be awarded actual damages, punitive damages, or the cost of legal action itself. So that's what we set up in place. We really don't deal with the exploitation in terms of other issues. And that's really what Professor Steinberg was talking about. And that's kind of the next step. That's where we need to go.
Thank you.
I might add, if I may, I think that getting involved, my first tip would be to go to that Quick Clicking Kids website, and I can take a moment and put that URL in the chat, and reach out to Chris McCarty, the youth activist who's also the executive director of Quick Clicking Kids, who works tirelessly along with Shreya and others to bring together coalitions and to help support new laws being brought forward in states that don't yet have them, and also to create a community of folks who may not live in a state, but who are able to submit written testimony, Zoom in, and so on to add support when there are state legislatures that are hearing these types of bills.
Thank you so much. We have another question from one of our staff editors.
Hi, my question is for Professor Khan because I'm taking estates this semester. I was wondering what you meant by that trusts are doing a lot of the work that should be spread outside of trust law, and then what your suggestions are for spreading out those responsibilities, and then any suggestions you have for improving the monitoring of trusts. Thank you.
I'm delighted you're taking trust in estates. I do want to emphasize what Senator Kaler said and what the others have said, that compensation is in some ways the easiest part of this. It's just because it's one quite visible part, it's something that can be regulated. So that's one part of the question. We've been talking about many of the other issues that are involved, ranging, I think, from a complete ban to publicizing some of these standards for when to share information about your kids, to figuring out how at the age of 18 the now adults can go back and wipe out anything that has ever been said about them online in the past. So to talking about expanding federal and state labor laws to address this. So I think that the compensation part is, which trusts are doing the work of right now, is just one part of this. I hope you've already started talking about trusts in T&E, but when a trust is set up, of course, there must be beneficiaries. The fiduciaries, the trustees, owe obligations to the beneficiaries. In most states, that requires providing information, responding to requests for information, and there's the possibility of suing for breach of fiduciary responsibilities. The problem is, and I appreciate all of the different damages that Senator Kaler just set out, it's making sure that minors, that the statute of limitations goes well beyond the age of 18, so it's a very long statute of limitations once a child is able to sue in their own name. It's also providing some way, someone getting information about those accounts on behalf of the minor to make sure that that information is being monitored. And then someone else, we rely on, it's typically parents, we rely on the parents to be setting aside this 15, 30, or 65%, but we don't know who's actually getting, we don't yet know how much the parents are actually getting when they enter into these contracts to advertise certain types of products. And so I think we need to get access to that information in order to ensure that the appropriate amount is being set aside. I should also say I'd be more than happy for you or anybody else on this call to email me with other suggestions on what trusts can do. I, of course, think trusts are, as I teach my students, incredibly flexible mechanisms. They can be adapted to many different situations, and clearly they are being adapted in this situation. But the lack of information and the lack of monitoring do concern me here.
Can I just add very quickly, and thank you, Professor Khan. We are already in good email touch, but I will be taking you up on your generous offer to email further, and I hope others do as well. Just to add, I just was reviewing my ever updated spreadsheet here of the roughly 20% of states that have brought forward laws. All of them do refer to a trust. Some of them say blocked, some of them are specifically referring to the Uniform Transfer to Minors Act, and I think also when it comes to enforcement and remedies across this roughly 20% of states, there is very wide variation. Illinois has fortunately, and I think quite wisely, given a very clear set of remedies and set up an enforcement mechanism within the family, and taking a little bit almost of a private attorney general model in terms of having the minor, upon achieving the age of majority, being able to do this, totally understanding too the questions that have been brought up about sort of how is the minor going to know. We do see some states not yet giving that much thought to what enforcement and remedies might look like, and also some states not yet giving that much thought to could there or should there be a role for one or more regulatory agencies, understanding and appreciating, Senator, as you were saying, that might be, if you're talking about the, Department of Labor, for instance, that could start to get to be quite a big lift. So hope those stats are helpful.
Professor Connie mentioned about how do you know what compensation is coming into the parents. We dealt with that issue as well. I guess we kind of figured out that really, if parents are filing their income taxes right, it should appear in their income tax statements. And so we kind of use that as a basis that if all of a sudden you see there's a lot of compensation coming from that, at least gives the child some track record as to what has happened.
And Illinois does, and Senator, if I'm misquoting, please correct. You are the expert here on your state. I believe Illinois does also contain in the private right of action for the former child influencer, it includes if the parents have not been doing the required record keeping. Right. And so right. I do see some thriving future practice areas for today's law students in Illinois and other jurisdictions when you look at this intersection of family law, internet law, and entertainment law. Right.
Yeah, it's almost a law that was passed just to say, parents beware.
Yeah.
If you're going to do this, know that there are some stipulations and you have to do it right.
Right. Thank you so much. But before we conclude, Charlotte, could you come up here for a second with Linda?
Also, I just want to say very quickly, we did have a couple more questions from students. I will absolutely be sharing information because this has been a really fantastic crowd. And I just want to thank everyone for attending today before I put the mic down.
And I think Law Review would like to thank the two of you.
Yes, yeah. There you go.
Thank you. You want to say something?
Thank you.
Thank you to our wonderful panelists. Can we get a round of applause, please, for everyone? And a round of applause for Professor Olnick for taking time to moderate for us today. Thank you so much.
Thank you.
And then
yes,
a big
you.
Thank you for Lyndall and Charlotte, who have been planning this thing since March. You've done so well, and we are so proud of you and thankful for planning this amazing series for us. So thank you.
Thanks again, everyone.
All right, this was a wonderful surprise. I may cry. This has been a really humbling and wonderful experience for both me and Charlotte. If any staff editor is interested in Symposium running for that position, I encourage you to reach out to us. And again, a huge thank you to our panelists. I have been inspired by your work for years now. So this has not only been a very legally fulfilling experience for me, but actually quite a dream come true. So I thank you a lot for coming today.
Thank you.